All right, so the title of our presentation is The Small Business Owner's Guide to Paid Leave, and we are going to cover information about the Connecticut Paid Leave Program. We'll also talk about the FMLA, or the Family and Medical Leave Act, and how it interacts with, but also how it's different from Connecticut Paid Leave. We'll talk about the implementation of both the Connecticut Paid Leave Act and Connecticut FMLA. We will leave you with some additional resources where you can get more information, and as I mentioned, have time for Q&A. So a quick overview of the Connecticut Paid Leave Authority. The authority is a quasi-public entity that oversees the Connecticut Paid Leave Program. We have 5 main areas of focus. The first is outreach and engagement, so making sure that everyone who's impacted by the program understands their responsibilities and benefits from it. We develop the policies and procedures needed to run the program. We establish the trust fund contribution rate and receive contributions. We approve and audit private plans. That's for businesses who would opt to have their own insurance plan instead of participating in the state program. And we administer claims for benefits in conjunction with our third-party claims administrator, which is AFLAC. Some key dates to kind of illustrate how we got to where we are today. In November of 2020, employers began registering with the Connecticut Paid Leave Authority. And on January 1st of 2021, employers were to begin deducting contributions from their workers. The contribution rate is 0.5%. Every quarter, businesses remit their contributions electronically through our online portal. There is a 30-day grace period at the end of the quarter. So the next due date is January 31st, and that is for the period of October, November, December of 2021. In December of 2021, we opened our application portal, and we were able to begin accepting applications for folks who knew of leaves that were coming up this year. And just a few weeks ago, starting on January 1st, approved contributing workers, sole proprietors, and self-employed individuals were able to begin receiving benefits for qualifying events. I do want to make a note that the Department of Labor has authorized what we call a catch-up period, which runs from now through March 31st. That is for employers who may not have deducted contributions from employees last year. And so they can now take an additional 1% for a total of 1.5% just through March 31st to make up for those missed deductions. After March 31st, the contribution rate cannot be higher than 0.5% without special permission from the Department of Labor. So who is covered by the program? Most employers in Connecticut who have 1 or more people working for them are considered covered employers, and therefore their workers are covered. That does include nonprofits and private sector employers with a unionized workforce. Now, sole proprietors or self-employed individuals are not required by statute to participate, but they can opt in if they would like to do so. The only caveat is that sole proprietors or self-employed individuals must stay in the plan for a minimum of 3 years if they do opt in. They contribute at the same rate as everyone else, so 0.5%. There are a couple of exclusions from the program. So employees who would not be covered are employees of the federal government, employees of the state of Connecticut, except as to covered public employees, which I'll discuss in just a moment. The same goes for municipalities and local or regional boards of education, unless they have covered public employees. And employees of non-public elementary and secondary schools are also excluded. Then we also have exclusions such as railroad workers, folks who work for the government of another state, employees of sovereign nations, which would include employees at our 2 casinos, truck drivers, and spouses of active duty military who pay taxes in their home state instead of in Connecticut when they are deployed here. Now, covered public employees, you heard me mention on the previous slide. So covered public employees include non-unionized employees of the state of Connecticut. It also includes unionized employees of the state who collectively bargain to be included in the program. And then as for municipalities and local or regional boards of ed, if the unionized employees collectively bargain to be included in the Connecticut Paid Leave Program, then all of the employees, including the non-unionized, are also included. You can see the definition of municipality down there at the bottom of the screen. And municipality includes towns and cities like we would normally think of, but also things like housing authorities, flood commissions, etc. I mentioned that sole proprietors and independent contractors or self-employed individuals can opt in. If you pay self-employment taxes as defined by the IRS, then you are not considered an employee. And so you do not have that requirement to participate in the program. And in that case, you can choose to enroll if you wish to. As I mentioned, you would have to be enrolled for at least 3 years. You would contribute half of 1% of your earnings. But if you are a sole proprietor and you also have employees who are on your payroll, even if you choose not to opt in for yourself, you do have to take those contributions from employees and remit them. And if you receive a W-2 from your company, then you are considered to be an employee. And that's true even if you are the owner or an officer of the company. So let's talk about the management of the contributions. So the employee contributes 1/2 of 1%, which the employer deducts through payroll deduction. The contributions are post-tax and they're based on the employee's wages as they're calculated for FICA purposes. The contributions are capped at the Social Security limit, which is currently $147,000. So regardless of how much an employee earns above that $147,000, their max contribution rate is capped, and that works out to be just over $14 per week. The employer remits the contributions quarterly to the Paid Leave Authority. We receive those contributions and we validate them against data we have from other state agencies to ensure that they're accurate based on payroll. The contributions are deposited into the Paid Leave Trust Fund, and that trust fund is the source from which benefits are paid. Now we want to talk a little bit about FMLA and how it relates to Connecticut paid leave. If you are a business with 75 or more employees, you're probably already familiar with Connecticut FMLA, but if you have fewer, you may not have been familiar with this before. FMLA is the Family and Medical Leave Act, and it provides job protection when someone needs to take time away from work for certain qualifying family or health reasons. However, it does not provide income replacement. And so there's both a federal FMLA and a state FMLA. And both laws are the same in that they state that the leave is unpaid. Now, some employers do provide payment to their employees while they're on leave. The most common example might be like a paid parental leave or paid maternity leave period. But that's an option that has never been a requirement. And many employers will also either permit or require their employees to use their accrued PTO while they're out in order to have income replacement. Connecticut FMLA changed very significantly as of January 1st of this year. The big changes are as follows. Previously, there was a minimum hours worked requirement for job protection. That has gone away. So there is no longer a minimum number of hours that someone must have worked to have their job protected when they're out for an eligible reason. The job protection now attaches at 3 months rather than at 12 months. So it used to be 12 months of employment with a minimum of 1,000 hours of work. It's now 3 months of employment with no minimum number of hours worked. It also now applies to businesses in Connecticut with 1 or more employees. And this is why I mentioned that if you have 75 or more, you may already be familiar with it, because that was previously the threshold was 75 or more employees to be subject to Connecticut FMLA. There are also some expanded reasons for leave with this change, which does include a provision for family violence. And there's an expanded definition of family, which I'll get to in a moment. So this shows you a side-by-side comparison of Connecticut FMLA as it was previously versus how it is now. Again, applies to businesses with 1 or more employees. Job protection is after 3 months with no hours worked requirement. The length of time of job protection provided under FMLA has also changed. It was previously 16 weeks in a 24-month period. That has changed to up to 12 weeks of leave in a 12-month period for all leave reasons. One thing that has not changed is that job protection for military caregiver leave was and continues to be up to 26 weeks. Another new addition that started just this year is that an additional 2 weeks of leave are potentially available for incapacitation experienced during pregnancy. And the last significant change is while an employer can still require their employee to use accrued PTO, they cannot require them to exhaust it any longer. So they must allow that employee to keep up to 2 weeks of their accrued PTO for future use. So for example, if an employee is going out on leave and they're having a surgery and their doctor tells them that they need to be out for 4 weeks to recover, and that employee has 4 weeks of accrued PTO, the employer can require them to use 2 of those weeks in order to receive pay while they're out, but they must allow them to retain those additional 2 weeks for future use if the employee so chooses. If the employee wants to use the additional 2 weeks, they certainly can, but the employer cannot compel them to do so. So what is Connecticut paid leave? We often use the acronym CTPL. So whereas FMLA provides job protection, Connecticut paid leave provides the income replacement piece. Connecticut paid leave does not provide the job protection piece. So as I said, they are 2 separate laws, but they work together. We sometimes use CTPL to stand for the statute itself, the Connecticut Paid Leave Act, the program, and also the Paid Leave Authority. You may also hear the acronym PFML or the phrase paid family and medical leave, and that also refers to Connecticut paid leave. There are 6 different reasons that you can apply for either job protected leave or Connecticut paid leave income replacement benefits. And they are as follows. The first is medical leave. That's leave that an employee would take to receive treatment for or recover from their own serious health condition. Serving as an organ or bone marrow donor does qualify as a serious health condition, as does pregnancy. And there is a legal definition for a serious health condition, which includes things like an overnight stay in the hospital or continuing treatment by a healthcare provider, prescription medications, etc. The second type of leave is called bonding leave, and bonding leave is taken by parents to bond with a new child that's entered their home through birth, adoption, or foster care. It refers not only to the physical attachment, but also the emotional attachment formed between the parent and child. Both mothers and fathers can take bonding leave, and it can be taken at any time during the year immediately following the child's entrance into the home. In the case of adoption or foster care, bonding leave can also be used to attend to pre-placement activities. The third type of leave is caregiver leave. Caregiver leave is leave that is taken by an employee to care for a family member who's experiencing a serious health condition. Family violence leave is a unique provision to Connecticut. So family violence leave can be taken by an employee who's experiencing family violence, and they could use that leave to obtain services from a victim services organization, to relocate, to seek medical or psychological care or counseling, and to attend court proceedings, etc. Up to 12 days can be used for family violence in a calendar year. And then the last 2 types of leave pertain to the military. One is called qualifying exigency leave. This is leave that a worker can take if they are notified that their parent, spouse, or child is on federal active duty or has been notified of a cause to federal active duty. And this would be for them to address any circumstances that need to be taken care of before that spouse, parent, or child is deployed. So, for example, perhaps the military spouse is the one who's the primary caregiver for the children. They could use qualifying exigency leave in order to make alternative childcare arrangements while that person is deployed. The last leave is military caregiver leave. This is leave taken by an employee to care for a military family member who is injured during the line of federal active duty. Now, given the circumstances currently in the world, we're getting a lot of questions about COVID and if COVID is a reason to receive paid leave benefits. And so the answer is that simply being exposed to or diagnosed with COVID is not in and of itself considered a serious health condition. What would make it eligible for Connecticut paid leave benefits is if one or more of the following conditions, or excuse me, elements of a serious health condition were met, such as an overnight stay in a hospital, if the employee was incapacitated due to the diagnosis with COVID and that required ongoing medical treatment, like multiple appointments with their doctor, prescription medication, etc., or if it resulted in or exacerbated a chronic condition. Now, with caregiver leave, there is an expanded definition of family that's a little bit different that I want to make sure everyone understands. So under the Connecticut law, an employee can take caregiver leave and receive paid leave benefits for the relationships that you see listed on the screen: a parent, a spouse, a child of any age, a sibling, a grandparent, or grandchild, or an individual related to the employee by blood or affinity. And what does that mean? Related by affinity essentially means if you have a personal bond with someone that is like one of those family relationships that you just saw, regardless of if you're legally or biologically related to them. A couple of examples here. One might be if you have an aunt or an uncle that relies on you for unpaid care, and your relationship with that person is more akin to a mother or father and child. That could be considered relationship by affinity. A very common example might be an unmarried couple. They live together, they perhaps have children together, share a home, share finances, but they're not legally married, and therefore they're not legally related to each other. That would be another example of related by affinity. Now let's take a look at the eligibility requirements. All the way on the left, you see the eligibility requirements for federal FMLA. Federal FMLA is not changing, but it's in here just to give you a point of reference and context compared to the state law. Federal FMLA only applies to businesses with 50 or more employees. And in order for someone to be eligible for federal FMLA, they must have been employed for at least 12 months and worked at least 1,250 hours in the 12 months immediately before their leave. Connecticut FMLA, again, effective as of just a few weeks ago, employed by your employer for at least 3 months and no minimum number of hours worked in order to be eligible for job protection. And then on the Connecticut paid leave side, in order to be eligible for benefits, a person must have earned at least $2,325 in what we call the base period, which is the highest earning quarter of the first 4 of the past 5 quarters. That can come from 1 or more covered employers. So if there's a part-time employee who works 2 or 3 part-time jobs with covered employers, as long as their total wages in that base period equal $2,325 or greater, they would meet that requirement. And then additionally, the person needs to either be currently employed and working in Connecticut, or if they're not employed, they were employed during the 12 weeks immediately before their leave. If the person is a sole proprietor or self-employed individual, they must have opted into the program. And specifically with sole proprietors and self-employed, they must also be a resident of Connecticut. That's only for sole proprietors and self-employed. Now, what are the entitlements? So how long can someone either have job protected leave under FMLA or receive benefits under Connecticut paid leave? Under federal FMLA, a person is eligible for up to 12 weeks of job protection in a 12-month period for all leave reasons, with the exception of military caregiver leave, in which case they're eligible for up to 26 weeks in a 12-month period. Under Connecticut FMLA, those first 2 are the same, 12 weeks in a 12-month period for most leave reasons, up to 26 weeks in a 12-month period for military caregiver. The differences with Connecticut FMLA are that up to 12 days in a calendar year can be used for family violence pursuant to the Family Violence Leave Act. That's not 12 days in addition to the 12 weeks. That means 12 days of the 12 weeks can be used for family violence leave. And then additionally, a patient who is incapacitated during their pregnancy may also receive up to 2 additional weeks. The benefits for Connecticut paid leave. Up to 12 weeks in a 12-month period for all leave reasons, including military caregiver leave. So if someone was taking military caregiver leave, they could potentially have 26 weeks of job protection within a 12-month period, but only 12 of those weeks would be eligible for income replacement under Connecticut paid leave. Up to 12 days in the 12-month period can be used for, 12-week period could be used for family violence leave, and the additional 2 weeks of income replacement may be available for incapacitation during pregnancy. Let's talk about how we actually implement the Connecticut Paid Leave Act. We have 4 buckets here with a summary of the responsibilities of each person underneath. So the worker, what does the worker need to do? If they know that they're going to submit a Connecticut paid leave claim, they need to create an account with Connecticut paid leave if they're going to submit online. They need to submit their application in a timely fashion. That can be done either online or by phone. They need to provide supporting documentation for the type of leave that they're taking. That might be medical documentation, adoption documents, military orders. AFLAC would let the worker know what kind of documentation they need to submit based on the type of leave they're applying for. They also would need to update their account with their absence info, as well as information about other sources of income they may be receiving. And of course, notify their employer about their claim, because that is the responsibility of the worker, and we don't want any employers to not know that their employee is planning to be taking leave. For the employer, we really try to keep it very, very easy and minimal work for them. So the biggest thing the employer needs to do is, when the worker creates that claim, they will receive what's called an employment verification form, and they will give it to their employer. The employer fills that out with some information to validate their typical work schedule, other sources of income they may be receiving, etc. As far as paperwork goes, that's the only thing we request from the employer. But beyond that, the employer would also want to notify their worker about their PTO policies, including their short-term disability policies, and of course, refrain from discrimination or retaliation. We here at the Paid Leave Authority, in conjunction with our partner AFLAC, will determine the worker's eligibility. We'll review the supporting documentation and either approve or deny the claim as appropriate. We'll calculate and pay the benefits, monitor the claims, assess requests for reconsideration. What reconsideration means is, if someone's claim is denied or they're told they're not eligible, they can request a reconsideration where their entire case and claim would be reviewed again. So perhaps there was a piece of documentation missing, and that's why the claim was denied. They would be able to submit that documentation and have that reconsidered for a new decision. We also investigate potential fraud and impose penalties as appropriate. And the Connecticut Department of Labor hears appeals related to the denial of claims. So if someone was denied, they requested a reconsideration, we reviewed all the documentation again, they were again denied, then that person could go to the Department of Labor to appeal that denial. Here's the way the process flows. The worker submits the claim. So they submit the claim using their online portal after they've created an account with Connecticut Paid Leave, or they call the toll-free number. They submit their application and the supporting documentation. AFLAC will first determine if, in fact, this worker is eligible based on the eligibility criteria. So they'll look at their earnings via DOL data and other documentation, make sure that they work for a covered employer or that they're registered if they're a sole proprietor. If it is determined that the worker is not eligible, AFLAC would notify that worker and offer the right to request reconsideration. Once we determine that the person is in fact eligible, AFLAC will then determine if the claim is approved. Based on the documentation, the employment verification, the claim will be approved or denied. AFLAC will then calculate the benefits, and that will be based on DOL data as well as any other type of income or offsets that are being received from PTO, from short-term disability, etc. AFLAC issues the benefit payment, and the benefits are issued via either what's called a stored value card, which is essentially a pre-loaded Visa debit card, or a direct deposit into the person's bank account. And benefits are issued on Tuesday. Currently, it's 2 weeks in arrears, but shortly we'll be changing that to 1 week in arrears. And the worker is to notify AFLAC of any changes. So if they're able to return to work sooner than they thought they were going to, or conversely, if they need to take their healthcare provider decides they need longer, they're to keep AFLAC updated of any changes. Now, this is an example of the employment verification form. Based on recent feedback from employers, we're just streamlining it, so it may look a little bit different when you see it, but the basic information will stay the same. The areas I highlighted, we just really want to make sure that you fill out your employer name as well as a contact name, phone number, and contact email for someone at the employer's location. Because if there are any issues, we want to be able to contact someone and get that information that we need so that we can expedite this process for the employee. Once the employer fills this out, on the actual form, there is a fax number and an email address, and you can use one of those to return it directly to AFLAC. Now, in terms of the benefit calculations, AFLAC does those benefit calculations. So you as the employer are not responsible for trying to figure out how much this employee is going to get paid. But just some basic guidelines. For a minimum wage worker, they would receive 95% of their base weekly earnings. Those who earn above minimum wage, there's a slightly different benefit calculation based on how much they make. But in all cases, the weekly maximum benefit amount is capped at 60 times the minimum wage. And that currently works out to $780 per week. A worker can never receive more than 100% of their normal wages when paid leave benefits are combined with any employer-provided benefits. If you have workers that come to you and they're curious how much they may be able to expect, the best thing to do would be to direct them to the benefits estimator on our website. You see over on the left, on the right, what that looks like. So the employee would select their pay period frequency of either weekly, quarterly, or annual, how much they make during that time period, and when they click estimate, they'll get a calculation there. Now, how will the Connecticut paid leave benefit interact with any kind of employer-provided income? So we have 4 scenarios here to help illustrate this. In scenario number 1, your worker has no PTO to use for their time that they'll be out on FMLA. In that case, they would receive the full amount of the Connecticut paid leave benefit that they're eligible for the full period of their leave. That's a pretty simple one. In scenario number 2, the worker has enough PTO to cover their entire leave. So they would be receiving PTO from the employer that's equal to their regular pay. In that case, the worker would not be eligible for any benefits from Connecticut paid leave. In scenario number 3, the worker has PTO available at their regular pay to cover part of their time out on leave. So maybe they need to be out for 5 weeks. They have enough PTO to be able to cover 2 weeks. In that case, the Connecticut paid leave benefits would start after the PTO benefits from the employer are exhausted, with the caveat that now, because of the new changes to Connecticut FMLA, that employee has to be allowed to keep up to 2 weeks of their PTO. And then in the 4th scenario, the employee has some PTO, but it pays less than their regular pay. So the worker would be eligible to get the benefit at the start of their leave. Connecticut paid leave would pay the benefits pursuant to the law, and the employer would coordinate the benefits to make up any wage differences so that the employee did not get more than 100% of their regular pay. When an employee is approved for leave, the employer will receive an email to the email address that they put on that employment verification form, notifying them that this person has been approved for leave with this particular start date, this end date, and what their weekly benefit amount will be. What do your workers need to know? So if someone comes to you and they say that they're going to need to take some leave, here are the things that you want to make sure you communicate to them. The first is, will you require or permit them to use their PTO while they're out? The second is, are there any rules about the use of that time? So for example, if they're needing to take time off to care for a sick relative, can they use their own sick time for that, or do they have to use vacation time? And third, if you offer a short-term disability policy, you would want to let them know if the policy states that they must exhaust their employer-provided PTO and Connecticut paid leave benefits first, or if the short-term disability policy would reduce the amount it pays by Connecticut paid leave, PTO, or similar. And we get a lot of questions about how short-term disability plans interact with Connecticut paid leave, and it really is dependent on how your policy is written. So you would want to take that policy out and see what it says. In many cases, it's written so that the short-term disability policy, the short-term disability is the payer of last resort, but that's not in all cases. Now, that's what we talked about is all about the paid part, right? The Connecticut paid leave part, the income replacement. Now we're going to talk a bit about the job protected part, the Connecticut FMLA. Again, we have responsibilities for each of the 4 entities that are involved with Connecticut FMLA. The worker is to notify their employer about the need to take time off in a timely fashion. What is recommended is 30 days in advance for foreseeable reasons and as soon as possible for unforeseeable reasons. The worker would submit their application for job protection directly to the employer. So job protection under FMLA is coordinated between the employer and the employee. The employer would ask the employee for whatever kind of supporting documentation they needed for the particular type of claim. And the worker would also comply with the employer attendance and call-in policies. That's particularly important for intermittent leave, where someone might, for example, suffer from migraine headaches and not be able to predict when they're going to need to take time off. So they would want to comply with the attendance policies. The employer, ideally the employer should have an established leave policy already, including their rules about PTO usage. They would want to make sure they have the FMLA poster posted in their workplace or circulated electronically, process leave requests, monitor leave usage, and manage the worker's return to work. At the Connecticut Paid Leave Authority, we do not have any official responsibilities related to Connecticut FMLA. We do provide this information as part of our training and education because it is so closely intertwined, but Connecticut Department of Labor is the one who oversees Connecticut FMLA. They provide guidance to workers and employers, and they also investigate complaints about the denial of FMLA claims. Here's how the process flows for job protected leave. First, the worker notifies their employer that they need to take time off. They do not have to say FMLA if it can be reasonably inferred that the reason might fall under an FMLA reason. Then the employer should start the process of considering whether the reason qualifies for job protection. The employer determines if the worker is eligible for FMLA. That's not the actual leave approval. That's just them saying, hey, it sounds like what you're telling me you're going out for surgery. Sounds like that's something that might qualify for FMLA. Here are the documents I need you to provide me with. The employer has 5 business days to notify the worker of their eligibility and provide a notice of rights and responsibilities. The worker then procures and provides the required documentation. They have 15 days to provide the documentation to the employer. If they say they're having difficulty obtaining the documents, the employer should give them some additional time. And then the employer reviews everything within 5 business days once they've received all the documentation, and they notify the worker if their request for job protected leave is approved under Connecticut FMLA. The worker reports to the employer when they are actually taking leave. The employer tracks it to ensure that they do not exceed the 12 weeks. And then the employer returns the worker to their job that they held before the leave. That's really the whole basis of FMLA and job protection, is that the worker has the right to get their same job back when they return. So same terms and conditions, same schedule. You can't take someone who used to work the 9 to 5 shift and suddenly tell them that they have to work the 11 p.m. to 7 a.m. shift, for example. The employer also cannot say that the employee has to be 100% fit for duty or totally recovered. They have to consider the Americans with Disabilities Act and the Connecticut Fair Employment Practices Act, which may require reasonable accommodations for an employee who's returning. In all cases, it is an employer's right and responsibility to designate time off that qualifies under FMLA as FMLA. So even if a worker says, hey, I'm going out, I'm having surgery, I don't want this to be FMLA, I just want to use my vacation time, it's your right and responsibility as the employer to designate FMLA as such, and it protects you and the employee. Now, in addition to what we've discussed, there are a couple of other laws that provide job protected leave that you should be aware of. So we've talked pretty extensively about the federal and Connecticut FMLA laws. There's also workers' compensation for covered on-the-job illness or injuries, and that provides both job protection and income replacement. It's worth noting here that a person is not eligible for Connecticut paid leave if they are receiving workers' compensation or unemployment. There are also a couple of other laws, including the Americans with Disabilities Act and the Pregnancy Disabilities Act, both of which apply to businesses with 15 or more employees. and the Connecticut Fair Employment Practices Act, which applies to businesses with 3 or more employees. And for those 3, leave may be considered a reasonable accommodation that has to be provided. That's a lot of information. There are a number of resources available that I want to make you aware of. On our website, you can download the different documents you see, which you can provide to employees. There's a rack card. There's information that can go into their paycheck. There's an employee fact sheet. And then there are 2 downloadable guides for employers. One's called the Employer Toolkit. One is a Human Resources Toolkit. For any FMLA related questions, the Connecticut Department of Labor has put up a new landing page. You can see the web address highlighted there, and they also have downloadable forms, frequently asked questions, etc. So that's the source to go to for anything FMLA related. Just a couple of examples of the forms that you can get from there. And if you do have any questions, we do not have a call center, but we do have a contact us portal that's available at ctpaidleave.org. You can indicate the reason that you're reaching out. And if you would prefer to speak to someone as opposed to emailing, you just indicate that on your form and someone will call you. And we do reply within 48 hours. We also have several hundred frequently asked questions on our website. And we have a ton of videos, some of which are embedded in the website and some of which can be found on our YouTube page. So we have guides for employers, for employees. We have tutorials for how to apply for leave, how to create an account, etc. And with that, I will stop sharing. And I saw one question. Okay, Marianne said she's received 2 claim forms. There was no request to validate income. How does the state know the employee's salary? That is information that we get from the Connecticut Department of Labor. And I see something in the chat. Okay, so Carter, yes, the slides will be sent to you. Is there a separate employment verification form for sole proprietors? And how do you determine if PTO is available for sole proprietors? That's a great question. I've actually never been asked that question about sole proprietors. So Carter, I will find out the answer for you and I will send it out to you. Yeah, I'll find out. I don't want to give misinformation, so I'll find out. So again, this will be sent to you, or the recording will be sent to you and the slides will be sent to you. I don't see any other questions. I guess I was really speedy today. It's only 3:40. But thank you so much for attending. Again, our website is a wealth of information. And if you do have any questions that you cannot find on the website, please use the contact us portal and someone will get back to you. Thanks everybody so much for joining me. And I hope you have a wonderful afternoon. Take care.